What if a spouse dies without a will? Well, I'm terribly sorry if that's a situation that's confronting you. No one deserves to lose a partner, and my condolences. Now, your immediate priority is going to be the handling and care of the body of the decedent. Where the body is going to stay until your burial arrangements can be arranged, then planning the funeral and finding a place for the body to be interred or scattered, and then of course carrying out the interment or scattering of the person. This is obviously going to be a difficult time, so hold the ones you love extra close and lean on your family for support. Everyone's going to understand if you reach out. You have time before you have to get down to the court. In Virginia, no one can qualify on an estate in less than 30 days if there's no will. After 30 days, the immediate family can qualify, and after 60 days, creditors can qualify. When you are making your burial arrangements for your loved one with the funeral home and they're asking you how many death certificates you want, get extra. You probably only need 5 in the immediate short term, but you might need 10 to 15 down the road. So go ahead and get 10 to 15 death certificates, depending on how many accounts you think your loved one, your spouse, had, because you're going to need a death certificate for each place where they had money, and then down the road, if you ever need to prove that they died, you're going to need historical copies as well. It's only $5 per death certificate usually, so it's not the end of the world to have to order a lot. Okay, so after burial arrangements have been carried out or are underway, you're going to do what I call the voyage of discovery, where you are going to work on determining whether probate is going to be necessary. If your spouse has passed away, you probably held a lot of assets jointly with them, to include real property and bank accounts. But things that tend to be individually held are things like business bank accounts, money market accounts, investment accounts, and car titles, perhaps inherited property from someone else. That stuff might require extra work to inherit. So what you're looking for are any individually held assets that cumulatively exceed $50,000. You don't have to count tangible personal property unless you're really close to the boundary of $50,000. In Virginia, that's the magic number for when probate is going to be required, if there's personal property that exceeds $50,000 cumulatively. If you owned real property with your spouse as tenants by the entirety or as joint tenants with the right of survivorship, then no probate is going to be necessary, and the same for a bank account that's held jointly. Car titles, pretty straightforward. You have to go down to the DMV with the death certificate and the letters of qualification or the transfer of title forms. And what you might have to do first is you might have to request a copy of the title. And so if you get a copy of the title, then you can convey the title to a new person. If you are able to figure out that your spouse was sole on the title at the DMV, they'll often help you just transfer it into your name by filling out the forms at the same appointment. It's an in-person appointment. Handling it by mail is not always possible. It's better to just go down to the DMV and spend the 2 hours to get the car title transferred. All right, now if your spouse did leave a living trust, then the terms of that trust are going to be applicable to the distribution of that asset. Probably if you have an I love you trust arrangement that an attorney drafted up, you're going to be trustee and beneficiary of the trust, and your job is going to be to administer the trust to yourself or on behalf of the beneficiaries. Important note, if your spouse had a trust written for them by someone else, you're not going to get those assets unless that trust specifically says, if not spouse, then to you. The terms of the trust are going to dictate what happens to the benefits of that trust after your spouse passes away, and you may not have any idea what happens to them next. Now, if your spouse had children from a prior marriage, then you're going to have a bit of a different journey in administering your spouse's estate. The children from the prior relationship are going to be entitled to some benefit of their loved one's estate, and it's going to be at least half. Yeah, it's a lot. Your share of their estate is going to be pursuant to the family share allowances and the elective share provisions of Virginia Code. And the elective share provision is going to be based on the length of your marriage, where you get your full 1/2 of the estate after 15 years of marriage, but it's a graduated scale. So you can go look it up what the scale is based on the length of your marriage. Do you need an attorney in Virginia to administer an estate? Technically, no, it's optional. When you would hire an attorney depends on the facts and circumstances that present themselves in your matter. You would probably want an attorney if things were going to get contentious. That way your attorney can be your sword and your shield and can advise you. You can hire an attorney if you are dealing with an out-of-state location. You have property in Virginia, but you live somewhere else, then you could hire an attorney to administer that estate on your behalf. Another reason you might hire an attorney to administer an estate in Virginia is if you want a guide. If you want to get from A to B as efficiently as possible and with a guide that points out interesting and useful and relevant things along the way, then you could hire an attorney to take you through the process and be your guide. You need to be very careful about the delineation of responsibility. When our firm is approached and engaged to represent a fiduciary, the expectation still is that the fiduciary performs the work of administering the estate with advice and counsel from the attorney. It's a very important dynamic to get right. And the reason that it's so important in Virginia is because it has to be that way according to the way that estates are administered and the fees that fiduciaries are allowed to charge. If you delegate the authority of being the administrator in Virginia, the Commissioner of Accounts is going to deduct the attorney's fees from the fee that you're entitled to pay yourself. Now, if you're the sole beneficiary of your spouse's estate, you're probably not going to be paying a fee. And you also have a pretty smooth glide path because you might be the sole beneficiary and the sole personal representative, in which case you will qualify to file the statement in lieu of formal account. And so your glide path is going to be pretty easy as long as there are no adult children, and you don't necessarily need an attorney in that case. You can probably DIY it. If you need any assistance with administering an estate in Virginia, reach out to us at Speedwell Law.